to both of you, which is, how would you define judicial activism?
I think judicial activism is when a judge is unable or unwilling to separate out their own personal views of a circumstance or a case, and they rule consistent with those views rather than the law as they're required to do.
I would give the same answer, Senator Cruz, and also add, although judicial activism means many things to many different people, for me it also suggests a judge who goes outside, beyond the issues presented to the court. Judges are limited, they have quite a restrained role in that they are to only decide the issues presented to them, and one form of activism is going beyond that.
So what should a principal judge do if the law requires one outcome and your own personal, political, policy views are to the contrary? How does a judge resolve that conflict?
Oh, absolutely. The judge is duty-bound to follow the law. The law is the binding principle that guides a case, and judges need to methodically separate out their personal views. When I rule in my cases, I look at the facts, the law, and the parties' arguments in the same way in every case, and I methodically apply only those inputs because I'm trying very hard not to look at this case through anything other than the prism of the binding precedents of the Supreme Court and the D.C. Circuit. And so absolutely, there's no question that a judge has to set aside their personal views about how a case comes out and rule only consistent with the law.
That's absolutely correct, Senator. The roles of advocate and judge are completely different, but in the same way as an advocate that I set aside my personal opinions about my clients and what they were accused of or what they were guilty of, I would also set aside, if confirmed, my personal views, my personal convictions, if any, because the law is what guides and should guide judicial decision-making.
What are both of your views on the notion of a living constitution and whether we have a living constitution?
Senator, I have not had any cases that have required me to develop a view on constitutional interpretation of text in the way that the Supreme Court has to do and has to have thought about the tools of interpretation. I am aware that the Supreme Court, at least with respect to certain provisions of the Constitution that it has already interpreted, has looked at history and has focused on the original meaning of the text, say in the Second Amendment context in the Heller case. I just have not had any opportunity to do that. I have worked with those kinds of materials. When I was in private practice, I filed an amicus brief in which we argued using English common law about whether or not the English courts would have accepted evidence that had been extracted by torture.
So was this the amicus you did in the Boumediene case?
This was.
And was that pro bono representation?
That was. And I represented 20 former federal judges who wanted to make that point.
And what led you, look, with pro bono representation, that often reflects your own views. That's why frequently lawyers take it on. What led you to want to take that position?
Oh, I wasn't working alone. I was at a big law firm, and I was in their appellate division, and it was a client. It was a group of judges who I was assigned to work with as a part of that, my employment in the law firm.
But did you agree with the position you were advocating?
I was focused on my client's interest. I was doing what advocates do. I didn't have a personal view, really, of the issue other than just to make sure that I was making the most convincing argument that I could make on behalf of my clients.
So let me go back to the original question, which is, do you believe we have a living Constitution?
I believe that the Constitution is an enduring document. It has, the Supreme Court has said, a fixed meaning, that we're to look to the original words in the Constitution and interpret, as lower court judges, interpret provisions the way in which the Supreme Court does, and they look at the text and look at the original meaning. And so if I ever had one of those cases, that is how I would approach the task.
Ms. Jackson-Akumi?
Senator, thank you for the question. I don't find these phrases particularly useful. As a lawyer, a living Constitution is very similar to me, like judicial activism. It means so many different things to many different people. I do know the Supreme Court has not used those terms. I know that Chief Justice Marshall said that we have a Constitution that was meant to endure for ages, which it has, and to be adapted to the various crises of human affairs. And I think that is what has happened with our Constitution over the years. And beyond that, it's the supreme law of the land. And if confirmed, I would be bound by the Supreme Court's interpretations of the Constitution. It would not be my job to make law.
So if you could both tell me your view of the importance of the First Amendment, and in particular the protections of free speech and religious liberty.
Well, Senator, my view comports with the Supreme Court's view, because as a judge, I have to apply the doctrines of the Supreme Court. And it is very clear from the court's recent rulings, from the recent COVID cases, Trinity Lutheran, Masterpiece Cake Shop, and various others, that the court is looking into and is concerned about restrictions on religious liberty as a First Amendment principle. As well they should be, because the First Amendment includes religious freedom as a core constitutional right. So my views comport with what the Supreme Court has held about these things, and I would have to apply the Supreme Court's principles in any of my cases.
Ms. Jackson-Akumi?
I agree, Senator Cruz. The First Amendment is fundamental. It's foundational. All of the freedoms protected therein: speech, press, assembly, petitioning for redress, and religion.
Thank you.
Thanks, Senator Cruz. Senator Padilla?
Thank you, Mr. Chair. Before I begin my questions, I want to take a moment to remark on the significance of this hearing. As Chairman Durbin reminded us and noted at the outset of this hearing, over the past 4 years, the prior administration appointed 226 judges to the federal courts, almost 30% of the current federal judiciary. An overwhelming majority of those appointees, 189, were white, and nearly as many, 171, were men.